Welcome to today's clinic, presented by Legal Aid of North Carolina. Today we will talk about Social Security disability benefits for adults, how to apply for benefits, and what to do if your application is denied. There are two types of disability benefits: Social Security Disability Insurance, or SSDI, and Supplemental Security Income, or SSI. Your work history determines whether you are eligible for SSDI or SSI benefits. If you work, you and your employer pay FICA taxes. FICA stands for Federal Insurance Contributions Act, and it is money that your employer withholds from your paycheck to fund your future Social Security retirement and Medicare benefits. That money is held by the Social Security Administration in an account for your benefit. If you become disabled before reaching retirement age, you may receive Social Security disability benefits drawn off the same account, depending upon how long you worked and how recently you worked before becoming disabled. The amount of your disability benefit check is based on the amount of contributions in your account. If you never worked, or a long period of time passed between the time you last worked and the time you became disabled, you may qualify for SSI benefits. Unlike SSDI benefits, which are earned, SSI benefits are based on need. Even if you are disabled, you must meet certain income and asset limitations to qualify for SSI. The maximum benefit amount as of 2018 is $750 per month for an individual. In addition, there are asset limits as well. To qualify for SSI benefits, you cannot have more than $2,000 in assets. Certain assets are exempt, such as your home and household goods, one car, and burial spaces for you and your immediate family. You can find a full list of exempt assets by contacting your local Social Security office or online at www.ssa.gov. When you apply for benefits, and periodically once you are approved for benefits, you will be required to disclose information about your income and assets. It is important that you give complete and truthful responses. If you have more assets than you are allowed, your benefits can be terminated. Keep in mind that only income which is reported and from which FICA taxes are paid counts toward your eligibility account. You can use a screening tool provided by the Social Security Administration called the Benefits Eligibility Screening Tool, BEST, to help you determine what kind of benefits you might be eligible for. It can be found on their website at www.ssa.benefits.gov. This is not part of the application process, and your answers won't be recorded or used against you. Now let's talk about what it means to be disabled. The Social Security Administration has a very specific definition of disability. In order to be approved for SSDI or SSI, you must meet this definition. You must prove that you have a medical condition that prevents you from engaging in substantial gainful activity and that have lasted or are expected to last for 1 year or result in your death. If you make too much money, then you are engaging in substantial gainful activity and will not qualify for disability benefits. For example, non-blind individuals in 2018 making more than $1,180 per month are generally considered to be engaging in substantial gainful activity and therefore not disabled. If you have a severe condition, but it is temporary and not expected to last more than 1 year or result in death, you will not be found to be disabled. For example, if you break both legs and can't work, but will have the cast removed and return to work in 6 months, you will not be found to be disabled. The Social Security Administration uses a listing of impairments which describe, for each major body system, impairments considered severe enough to prevent an adult individual from doing any gainful activity. However, if you do not have a listed condition or your condition is not severe enough to match the listed impairment, you can still be approved for benefits if you can show that you have the functional equivalent of a listing, which prevents you from working. In determining whether someone is able to work, the Social Security Administration will consider your age, education, and work history. They will determine your residual functional capacity, also known as your RFC. RFC is an assessment of your maximum ability to do sustained work-related activities on a regular and continuing basis, 8 hours a day for 5 days a week, despite the limitations and restrictions that you have because of your medical conditions. They look at both physical and mental limitations and a combination of all your conditions. Basically, RFC is an evaluation of whether you have the capacity for full-time work and what kind of work you can do. The Social Security Administration then uses that to determine what, if any, types of jobs you can do based on your previous work history, experience, education, and age. The Social Security Administration will also consider whether you can be trained to do other types of work, which is why your age and educational background are so important to the decision of whether or not you are disabled. So, it is not enough for you to claim that you are unable to work at the same type of job you worked at before. To be approved for benefits, you have to show that you are unable to perform any type of significant work. Specifically, you must show that your condition or combination of conditions are so severe that you are not only unable to do your previous job, but cannot, considering your age, education, and work experience, engage in any other kind of substantial, gainful work, which exists in the national economy. It doesn't matter if the jobs you can do are available where you live, or whether any jobs are open, or even if you would be hired. It only matters that there are jobs you could do that exist in significant numbers, either in the region where you live or in several regions of the country. In addition, if your condition is treatable and the treatment will allow you to work, you may not be eligible for benefits, even if you don't receive the treatment. The Social Security Administration applies a different standard of disability for children. A child is someone under the age of 18 or under the age of 22 if the person is a student who regularly attends school. A child's eligibility is based on how he or she performs in different areas of development. Disabled children are only eligible for SSI benefits. If you would like more information on SSI disability benefits for children, you may contact www.ssa.gov. If you believe you are disabled and want to file a claim for Social Security disability benefits, you should start the process by contacting your local Social Security Administration office, notifying them that you would like to file. They will set up an appointment for you. The appointment can be by phone or in person. You can find the Social Security office closest to your home by calling the Social Security Administration at 1-800-772-1213 or online at www.ssa.gov. You may also apply on your own online. You need to complete Form SSA-16, SSA Disability Application, and SA 3368, Adult Disability Report. You must submit medical evidence from your healthcare providers to the Social Security Administration in support of your application for disability. A healthcare provider can include medical doctors, physician's assistants, nurse practitioners, counselors, and therapists. The medical evidence should verify your diagnosis or condition and explain your treatment and limitation. Medical evidence and records are absolutely necessary to prove your case. It is important that you make certain that the Social Security Administration receives copies of your medical records. Even if you sign a consent form allowing your healthcare professional to release your records to the Social Security Administration, you should verify that the records are sent. The Social Security Administration will deny your application if it does not receive your medical records. Your application will be reviewed by a claims examiner who will make a determination on your eligibility for benefits. The claims examiner will verify your non-medical eligibility requirements such as age, employment history, and medical status. The claims examiner will consider your eligibility for both SSDI and SSI benefits. Once the claims examiner determines your non-medical eligibility, the SSA sends your claim to Disability Determination Services in Raleigh. A different examiner will review your claim and medical records and other supporting documents and make a disability determination. If the Disability Determination Services does not have sufficient medical evidence to make a determination, they may refer you to an independent doctor for an examination. You should cooperate with any request for information that you receive from the Disability Determination Services. The Social Security Administration will pay for this evaluation. Once Disability Determination Services makes a decision on your disability, they return your case to your local Social Security office, which sends you a written notice of the decision. If your claim is denied, the notice will explain the reason for the denial and explain your appeal rights. Most claims are denied because Disability Determination Services determines that the applicant has not submitted enough evidence to prove that he or she is disabled. It is very common for an initial claim to be denied. If your claim is denied, you may file a request for reconsideration, SSA Form 561, Disability Report Appeal, SSA Form 3441, and Authorization to Disclose Information to the SSA, SSA Form 827. You must file your request for reconsideration no later than 60 days from the date you receive the notice denying your application. By filing a request for reconsideration, you are asking the Social Security Administration to take another look at your application and medical evidence. If you did not submit medical evidence with your initial claim, or if you have additional or new evidence you would like the Social Security Administration to review, you may submit these records with your request for reconsideration. Remember, you have 60 days to file your request for reconsideration. If you miss the deadline, you most likely will have to reapply for benefits. If that happens, you should consult with an attorney to discuss your options. The Social Security Administration will notify you in writing of its decision on your request for reconsideration. Again, most requests for reconsideration are denied, so don't be discouraged if you receive another denial letter. The notice will explain your appeal rights. To appeal a denial of a request for reconsideration, you must file a request for hearing by Administrative Law Judge, SSA Form 501. Disability Report Appeal, SSA Form 3441, and Authorization to Disclose Information to the SSA, SSA Form 827. You have 60 days from the date your request for reconsideration was denied to file your appeal forms. By appealing, you will receive a hearing before an administrative law judge who has not been involved in your case before and who will make an independent decision. This is your opportunity to explain why you should be found disabled, but be aware it can take between 18 to 24 months from the time you appeal before you receive your appeal hearing date. It is at this stage, after you have been denied your request for reconsideration and have asked for a hearing, that most private attorneys will consider taking your case. Social Security attorneys typically accept disability cases on a contingency basis. This means that they don't get paid unless you win your case. If you are found disabled, back to the date of your application, you may receive retroactive benefit payments to cover months since you filed your application. The attorney can be paid from the retroactive benefits, commonly referred to as the lump sum award. Now let's talk about how to prepare for your hearing. It is important that you prepare for your hearing by gathering all of your medical records and other evidence that you need to prove your case. The hearing before the administrative law judge is your best opportunity to be approved for benefits. However, the administrative law judge cannot approve you for benefits without current medical records. You will have approximately 75 days advance notice of your hearing date. If possible, your hearing will be scheduled at the Social Security office that is not more than 75 miles from where you live. You should try to appear at the hearing in person. However, if you are unable to do so, You may request that your hearing be conducted by telephone or video conference. As soon as you receive your hearing notice, you need to gather all of your recent medical records. Before your hearing, you will be permitted to review your entire file. You should take advantage of this opportunity to verify that your file contains all of your records. In addition, it is helpful to have a detailed statement from your doctor explaining how your condition or the limitations associated with your condition prevent you from working. For instance, the statement may say that you cannot lift more than 20 pounds or that you cannot stand for more than 20 minutes at a time. You may wish to obtain an evaluation from your local vocational rehabilitation office. They can conduct an assessment of your skills and recommend types of jobs, if any, that may suit you. If there are no jobs or your attempt at working is unsuccessful, then you can use this evidence to support your contention that you are unable to work. If you decided to contact vocational rehabilitation, you should do so as early in the appeal process as possible because it can take time to schedule and conduct evaluations. The hearing is your best opportunity to convince the Social Security Administration that you are disabled. You do not need to dress up for the hearing, but you should not dress too casually. Do not wear shorts, hats, flip-flops, or graphic t-shirts. Try to arrive early for your hearing. The administrative law judge will want to learn about you and will ask you questions. Everybody's case is different, and there are no right or wrong answers. You should just answer the questions honestly. You can present testimony about your work history, your condition, your limitations, and how your condition has affected your daily activities. You can bring your own notes to the hearing so that you remember to say what is important. For the hearing, you will need to provide a complete list of all your physical and mental health problems, as well as a list of all the doctors, clinics, and hospitals that you have been to for the last 2 years. Again, you need to submit the medical records from those visits. You must submit all of the evidence whenever you become aware of it, even if you don't think it is good for your case. You cannot submit just the part of your medical records that help you, but all of the medical records. You must submit any written evidence, including your medical records, no later than 5 business days before the date of the scheduled hearing. If you do not meet that deadline, the administrative law judge may not consider the evidence, unless you can show that the reason you missed the deadline was the fault of the Social Security Administration, or you have a physical, mental, education, or linguistics issues that prevented you in complying, or something unavoidable and beyond your control prevented you from submitting the evidence. At the hearing, the administrative law judge will want to know about your background. Be prepared to tell him or her what grade you finished in school, whether you needed extra help in school or attended special education classes, whether you have any learning disabilities, and whether you have a high school diploma, certificate, or GED. If you attended school or received any vocational training beyond high school, you should talk about what you studied and whether you completed any degrees or received any licenses. You need to tell the judge whether you have a driver's license. If you lost your license or if you can no longer drive due to your medical condition, explain that to the administrative law judge. Be prepared to provide the judge with a list of all the places you have worked for the last 15 years. Be prepared to explain to the judge how your medical problems keep you from returning to any of these jobs. The judge will be especially interested in your last job. Explain how long you worked at your last job and why you are no longer working there. Tell the judge what type of work you performed and why you can no longer do that kind of work. For example, if your last job required you to stand on your feet all day and your medical condition prevents you from standing more than 20 minutes at a time, tell that to the judge. The judge will also want to know what medications you're taking and how they affect you. Write a list of all the medications you take, both prescription and over the counter. Tell the judge why you take the medication, how much you take, and how frequently you take it. You can bring your medications to the hearing in case the judge wants to see them. You also want to let the judge know if your doctor has prescribed medical equipment that you use or should be using, such as a cane, a walker, or a brace. If your doctor has prescribed medication or special equipment that you cannot afford, tell that to the judge. Tell the judge what you are able to do. Explain how long you can walk without resting, how much you can lift or carry, how long you can stand or sit. It is also important to explain how you feel if you try to do too much. Be prepared to describe your symptoms. For example, if you are in pain or nauseous, dizzy, weak, or tired, describe how you feel. Explain how often you feel this way and how severe the feeling is and how long it lasts. If you take medication to help treat your symptoms, explain how the medication affects you. For instance, if you take a pain medication that makes you fall asleep, tell that to the judge. It is important that you provide the judge with a description of a typical day. Tell the judge what you can and cannot do. Do you live alone, or is there someone at home who helps you with your daily activities? Are you able to bathe and dress yourself without help? Are you able to cook or clean for yourself? How do you spend your days? How frequently do you leave the house? Are you able to spend time with family and friends? Tell the judge what activities besides work that you've had to limit or give up because of your conditions. For example, if you used to go shopping or attend worship services but can no longer do so, tell that to the judge. If you used to live independently but can no longer live alone, tell the judge. You can also have a friend or family member testify for you. The best witness is someone who lives with you or sees you frequently. They can testify about their personal observations about how your conditions affect you and what help you need. The administrative judge will send you a written notice of his or her decision. It may take several months to receive a decision. If you are again denied, you may file an appeal with the Social Security Appeals Council. You have 60 days to file an appeal with the Appeals Council. We recommend that you consult with a private attorney before filing an appeal with the Appeals Council. As we have noted, it is very important that you have medical evidence to support your contention that you are disabled. If you do not have health insurance and cannot afford to pay to see a doctor, there may be a free clinic in your area. For more information, you may contact the North Carolina Association of Free and Charitable Clinics at www.acafcc.org or www.freeclinic.org. freeclinics.com. As we explained earlier, the hearing before the administrative law judge is your best chance to be approved for benefits. Having an experienced attorney represent you at your hearing may increase your chances of being approved. To obtain a referral to a private attorney who assists with Social Security appeals, you may contact the North Carolina Bar Lawyer Referral Service at 800-662-7660. You may have to pay a consultation fee of $50 for 30 minutes. If you cannot find a private attorney willing to take your case, you may apply for help from Legal Aid of North Carolina at 866-219-5262. That concludes our presentation today. We hope that you found this clinic helpful.